It's been 2 years since the Bruen decision came down, but perhaps we need a little bit more clarification for these courts that don't particularly like the Second Amendment. We have multiple lawsuits being appealed to the Supreme Court on just that issue. Let's talk about it. Hey everybody, welcome back to the channel today with a lot of advocacy and petitions being signed to get several cases back in front of the Supreme Court as far as Second Amendment litigation is concerned. We've brought on the volunteer CRPA president, founding partner of Michelle and Associates to talk us through it. That is Chuck Michelle. Chuck, thanks for being with us today.
Always a pleasure, fellas. Thanks for having me.
Absolutely. But before we get into that today, guys, if you want to directly contribute to Second Amendment litigation in California or legislative advocacy in California, you can do that by liking, sharing, and subscribing to these videos. It really helps with the algorithms to push this message out there, which can also be really helpful for people as they go to the ballot box in November to decide on who's going to be writing the legislation for the next session. So, Chuck, you got many cases here. This is a little bit more of a federal conversation. I want to bring it back to California at the end here. But as far as the background is concerned, on the federal level, what exactly is going on with all of this advocacy to get more Second Amendment cases in front of the Supreme Court?
Well, right now, there are fights going on across the country, particularly in the battleground states like Illinois, Maryland, California, even Washington, Oregon, New York. There's the pushback to Bruen, the blue resistance to Bruen, I call it. They don't like the Bruen decision. They don't want a strong Second Amendment. That interferes with their agenda of a big centralized government that makes all your decisions in life for you. And so they don't like the possibility of civilians being armed. So they are doing everything they can to minimize the Bruen decision. When it comes, remember, there's basically three different kinds of cases: prohibited places, prohibited people, prohibited hardware, firearms, or related activities. So the CCW reckoning that has been happening in California, the Sacramento legislature tried to push back on that by making every place in the state a sensitive place where your CCW is invalid. They want to make CCWs useless. They also want to make it as hard as possible to get one. So they're trying to increase the costs and increase the wait time and make more hurdles that you have to jump through to get a CCW. On hardware, they're trying to ban as many firearms as they can by calling them assault weapons, even though that's not the case for most of these guns. And even an AR-15 is not an assault weapon. That's a made-up term. And then there's prohibited people. And there's a case in the Supreme Court right now, the Rahimi case, where a guy with a bad guy, frankly, a dangerous guy who shouldn't have his right to own firearms, in my opinion, was banned from possessing firearms. And the Fifth Circuit said that that's not consistent with historical tradition. And so they said that ban is unconstitutional. And so that case was argued in front of the Supreme Court a couple of months ago. So we'll expect a decision in June on that one. But so the bottom line is there's battles going on all across the country. And the ones that are in the Supreme Court right now are Antoniuk, which is the New York CCW over designate places as sensitive where CCWs are invalid. And there's 5 or so cases out of the Seventh Circuit, Illinois. The main case is Bivens, but there are several other cases, almost a dozen, I think maybe even a dozen other cases. I've lost track. There's so many state and federal cases challenging the Illinois ban on semi-autos and plus round magazines, that they've all been consolidated or coordinated or argued together or differently, but they were all argued in this, most of them were argued in the Seventh Circuit. We got a bad decision out of Judge Easterbrook and that 3-judge panel. And so all of those cases have now asked the Supreme Court to take those cases, grant cert, and basically strike down the Seventh Circuit's opinion. The other case that's percolating through the Supreme Court right now is Antoniuk out of New York on the CCW sensitive places challenge. But so those cases, those Illinois cases have been set for a conference in the Supreme Court for May 16th.
So yeah, you are looking at carbon copy legislation of stuff that we've seen here in California when you're talking about assault weapons bans as well as high capacity magazine bans. There's arguments to be made. We've been saying it for years. California and New York tend to be some pretty popular exporters of anti-Second Amendment legislation. Obviously, a reason for us to pay attention. As far as this conference is concerned, what actually happens in this conference? Is this an opportunity for every single one of those cases to be taken up by the Supreme Court? Traditionally, is it just going to be one case that they take? What's the process there?
Well, theoretically, they could take any case that seeks a petition for a writ of certiorari. That's an order from the Supreme Court telling a lower court that your decision was right or wrong. So once or twice a week, the Supreme Court holds internal conferences where the judges get together and vote on whether or not to grant cert. In other words, accept a case. Review by the Supreme Court is never automatic. It's discretionary. The court can take a case or simply not take a case. And most of the time, over 90% of the time, they just don't take the case. Cert is denied. These 5 cases, I think, make a compelling argument, particularly the case that I was involved, the brief that I was involved in helping write, that the Supreme Court really needs to take this now because of all the shenanigans going on in courts across the country that are ignoring Bruen. They're not following the mandate that the Supreme Court laid down in Bruen. They're just making stuff up as they go along, twisting Bruen. And this is what they did after Heller, too. The courts that didn't like the Supreme Court's decision twisted it into something that it was never meant to be and never was, so that they could uphold a bunch of gun control laws. Especially the Ninth Circuit was particularly egregious in the way they did that.
I was going to say, and we've talked about that a lot in past videos, just talking about how they're bringing forth the analogs or when they're even appropriate. It seems to be sort of being misused already. You have a Ninth Circuit that's going pretty erratic, making decisions that aren't necessarily predictable, where it seems like they might be able to be predictable. Is that sort of the outlook going into the Supreme Court potentially taking up a case here? I mean, I was even reading some of the arguments from some of these cases, and they're going as far to say if a firearm is used by military, then it doesn't apply to Second Amendment rights. If you're taking arguments that far, so close to Bruen having come down, is your expectation that if they take up another case, it would be a redefinition of Bruen, or would it be even a more grand thing that we were looking for, say, Bruen to do, which is to completely redefine the scope of how we look at Second Amendment cases?
Hopefully, the justices on the Supreme Court are as insulted and offended as we are by the way courts are treating the Bruen decision. The Bruen decision was very clear. You look at the text of the Second Amendment. It's not a test, it's just a question. Does the conduct that's being regulated implicate the Second Amendment language, the text? If it deals with keeping and bearing arms or related conduct, like going to the range or fixing a firearm or marksmanship or hunting or whatever, collecting, then it's covered by the text of the Second Amendment. Then you go to step 2, the burden shifts to the state to prove that there is a historical analog law, some kind of a law that existed around 1791 or shortly thereafter, that shows that the Founding Fathers would have tolerated the modern day law. Now, it's never going to be exactly the same, so it has to be analogous. By that, the Supreme Court made it clear what it meant. You have to look at what problem the historical law was seeking to solve and how it went about solving it. So you can't just say that there was this law that banned guns in bars, a couple hundred years ago, so now we can ban guns everywhere. There's no true historical analog there. The manner in which they addressed a problem is critical because they never addressed a problem with misuse of firearms by banning all the firearms from everyone. That's what the modern laws do. So if the Supreme Court is as offended as it should be, it could take one or more of these cases, a grant cert, and then set the record straight. Now, and basically forced the lower courts into submission to do what they told them to do in Bruen, which some of these lower courts don't want to do. Look at this. Look at Hawaii. They just said we're not issuing CCWs because it violates the spirit of aloha. Where's that in the Constitution? You know what I mean? So they're just making it up as the lower courts are making it up as they go along, and hopefully the Supreme Court will set that straight. Now, they could. So remember, in conference, it takes 4 votes of the 9 judges to accept a case for review, but it takes 5 votes to win the case. Now, we should have 6 votes at this point. One of the reasons we weren't getting some of the cases accepted after Heller and before Bruen was because they weren't sure they had 5 votes because Justice Kennedy was kind of on the fence. So some of our friends who otherwise might have been one of the 4 to vote to take a case voted not to take a case because they knew they didn't have 5 votes to win the case. But that should have changed now. So the court could vote to take any or all of the cases that are pending in front of it now. That's the 5 or so Illinois cases and 1 semi-auto case out of Maryland, the Bianchi case. And that's got its own tortured history where the 3-judge panel was apparently getting ready to issue a ruling striking down the law. And before it could do that, the en banc panel grabbed the case away from them and said, we're going to just hear this en banc before the 3-judge panel even got to rule. So that case is on the May 16th calendar too, to decide whether to take that. So what's the Supreme Court going to do? Will 4 judges vote to take any or all of those cases? I suspect what they'll do is pick one and take it and just hold all the others over. But they might not take, the odds are statistically speaking, they won't take any. That's just the way the odds are. Now, these cases, though, present a challenge to the Supreme Court that it really needs to resolve these questions. Now, I don't know what the Supreme Court is thinking in terms of the decision it's going to render in the Rahimi case. If it straightens out some of this methodology and makes it clear that the lower courts are doing it wrong, the court might just hold all 6 of these cases. They can vote to take a case, 1 or all the cases. They can vote to not take a case, 1 or all of the cases. They can vote to postpone the conference and roll it over as many times as they want. They could potentially take a case and not even have briefing and just say, your decision, lower court, is wrong. And here's what you didn't consider, and now reconsider what you said in light of what our instructions. So they could handle these in a number of different ways. And I know that we've got an election coming up, and assault weapons is a very emotion-laden buzzword that the gun ban lobby loves to use to try and inflame passions and get an emotional reaction. So they might not want to issue an opinion before November, but they won't be able to anyway, because even if they take one of these cases, it won't be heard until the next year's session, which begins on the first Monday in October 2024. And they won't have oral arguments or anything before the November election. So we'll get if they take one of these cases, we'll get a decision sometime next year.
Gotcha. So a lot of different paths that the Supreme Court could take with any of these cases. You have even more variance from there potentially when you include the Rahimi case in that mix. Let's talk about the implications for California and the Ninth Circuit really quick, because none of these cases that are being asked to be taken up by the Supreme Court currently, nor the Rahimi case, are from the Ninth Circuit. Being as optimistic as possible, whether that be one of these cases gets taken up and we get a good decision on it, or we get a good decision on Rahimi. Good decision meaning an effective opinion that would not allow the Ninth Circuit to continue the shenanigans that they've been giving us. What implications does it have with some of these cases? I mean, there are cases in front of the Supreme Court right now on high-capacity magazines. That's basically a carbon copy of the Duncan case. There are plenty of other cases in California that are arguing these exact same thing. If we get a good decision, what are the implications? Is it immediate that we have on California laws?
Well, it's immediate. The Supreme Court is the Supreme Court. All other courts are inferior courts. What the Court says goes, but it has to say it clearly enough and definitively enough that the lower courts, the inferior courts, can't weasel their way out of it, which is what they're trying to do. So yes, once we get that should have been Bruen should have been the end of it. It was clear, but so now I think the Supreme Court is going to have to really drive home what they said in Bruen, and to do that, they're going to have to say, you got this wrong. There is no test. Step one, the common use test, dangerous and unusual firearms are the only guns that can be banned as a class of firearm. And you have to, these historical analogs about, Bowie knives where some places you weren't allowed to bring a Bowie knife. That doesn't mean you can ban an entire class of firearm because of some old historical Bowie knife law. So as long as they clarify all that, that's a national precedent that applies everywhere. That's why the CRPA has been involved in amicus briefs in all of these Illinois cases, because it's going to set precedent that's going to apply in California. So you might see in the Duncan case, which was argued in front of the en banc panel, you might see them hold that case. If the Supreme Court grants cert on to any or all of these cases on May 15th, you might see this Ninth Circuit wait to see what the Supreme Court does before they issue a ruling in Duncan or any of the other cases. CRPA has half a dozen cases in the Ninth Circuit right now, most of which are bottled up behind Duncan, waiting to see what the Duncan court does.
Yeah, I was going to say, we already saw one lawsuit at the Ninth Circuit where the judges basically came out and said, we're not going to decide on this until Duncan. So you're saying that could potentially happen. So I guess that is an immediate implication potentially on Second Amendment litigation in California if they do grant cert to one of those cases. And then, hopefully soon thereafter, they are able to put that pin in there. What are your final thoughts on this, Chuck? How do you see the timeline going forward? What's your perspective?
Well, reading the tea leaves, I'm very hopeful that the Supreme Court will pick a sort of a lead case, very likely the Bianchi case with Paul Clement's office as the lead counsel, because they're very familiar with him as a Supreme Court advocate. And in the best of all worlds, they won't even have oral argument. They will just grant review, vacate the lower court decision, and remand it with some instructions on how to do the test right without even going through the whole next year. That's a long shot, but it would be the best result for us. If not, we have to keep fighting. We will win eventually, as long as they don't change the composition of the Supreme Court. So, and that's the long game that every town law, and don't be confused, the folks behind all of this litigation, the folks that are coaching the attorney generals in California, in Illinois, in New York, in Washington, in Oregon, are the lawyers that are employed by Michael Bloomberg, working for the Everytown Law Group. You want to see your nightmare come true, gun owner? Take a look at their website and see the stuff that they're involved in. So, and by the way, Bloomberg obviously is a billionaire. So, and we're fighting with small donations, mostly from true believers that believe in freedom and the right to keep and bear arms, that support the CRPA. So we appreciate every single donation we get. We use it very frugally. All my time is essentially pro bono, but the lawyers at my office, we bill a reduced rate. We're fighting, we're fighting against. This is kind of a David versus Goliath thing when it comes to finances on this, but we're winning in the lower courts. It's just that the Ninth Circuit is so openly hostile. But thankfully, the Ninth Circuit's composition has changed, and there are a lot of more friendly judges up there now, and they are going at each other in kind of unprecedented ways to make the judges who did not accept Heller and don't want to accept Bruen accept what the Supreme Court said. So I'm very hopeful that we may even get a slim majority win in the Duncan case and set the methodology straight. But if not, that the Supreme Court will take at least one of these cases and use it as an opportunity to tell the lower courts how to do their job right.
Well, I was going to say, as the attorneys are, very fortunately, David was pretty skilled with a slingshot. So it's definitely a battle worth fighting. We're gonna keep that fight going. Chuck, I want to thank you for your time and taking the time to explain this to us today. I appreciate it.
It was a pleasure, guys. And thank you for getting the word out. And thank everybody who can donate and help us with this cause. We're fighting for the soul of America and the freedom of ourselves and our children. So the stakes are pretty high.
Absolutely. Thanks. And guys, if you like content like this and want to see more, please, you can help directly with Second Amendment litigation and Second Amendment legislative efforts by liking, sharing, and subscribing to these videos. Hit that little notification bell so that you get notified when these things happen throughout the courts. Thanks, guys, and we'll see you on the next one.